that they should set exams. Elevation to the High Court, they've been taking exams. You take exams, you are interviewed, and everything. At least that's as I knew it. I don't know about now. And to the Supreme Court, too, it is in terms of how you arrive at the names of the people to be recommended by the Judicial Council and recommended to the President. That too has varied in one way or the other. Some of us always felt that let's state a policy and stick by it. Other times it would be names coming from left, right, and center, and it's all a big mess. So when you say that, and all these are procedural rather than the Constitution says that it goes to the maybe what it starts with an application, or it starts with headhunting, or it starts with picking a name out of a hat. There are so many vague areas when it comes to appointment of judicial officers. And it's been one of my personal big concerns. And that's another thing which I hope the amended or the revised Constitution is going to deal with. One, how are they even seen first? And then what is the process by which you make your selection? And what is the sifting procedure? All that. If you go looking for any document that's going to give you step by step what's supposed to happen, like if you go to, let's say, any of our banks, and you want to know the procedure by which somebody becomes is employed as a director, you will see where it is, how it is initiated, where it starts from, and so on and so forth, and all that and all that. As far as I'm aware, it's not like that even in a greater part of the public sector, and it's a weakness, and it's an omission that needs to be seen to. But with regard to the Chief Justice, okay, so she sent a list of names to the President. That's what she's supposed to have done, right? And then what happened? And then what happened?
I mean, the appointment was not done, but the committee takes the view that that was in breach of the Constitution.
That's petty.
That amounts to a breach of the state and misbehavior, amounts to state and misbehavior as well.
I beg to disagree.
I mean, and you say that is petty. Why that conclusion?
Because even in major cases, you're a lawyer, right? Not a law student, you're a lawyer.
To be called to the bar in October.
Oh, well, then you're practically a lawyer. But I think one of the biggest, main first things you learned was that you can get it right and you can get it wrong. The question is whether it is correctable. Is it not? In major cases, in capital offense cases, the trial judge can get it wrong, right? And that involves somebody's life, whether they're going to be found condemned to death, or they're going to be put into prison for life. Even that is not so gross as to lead to the judge, he got it wrong. Yeah, he got it wrong. You can get it wrong, you can get it right. So that is why I keep asking, and then what happened? Because in the end, you look at the gravity of the harm that was done, if any. If any. That's all I've got to say on that.
So as far as you are concerned, that also does not meet the threshold in your definition?
No, doesn't.
Do you think, and this is a general question, do you think from what you've heard about the allegations, it should have crossed the threshold? I mean, I've seen suggestions that you abstained from the vote at the Council of State level.
I cannot reveal what happened at the Council of State
level.
The
question is, do you think it crosses the threshold of a prima facie determination?
Do you think you can get me to?
No, my lady, it's a separate question.
No, you think you're separating it.
You have expressed an opinion on the 3 allegations that we discussed.
Yes, and so deduce. Deduce from what I've said. Yes.
Is it a fair deduction to say that
no.
the opinion is that it does not cross the threshold?
It does not cross the threshold. You know, you've already done your criminal procedure, because once you're bringing in a prima facie finding, you're sort of skirting the lines of criminal procedure more than you will be skirting the lines of civil procedure, right? Okay. And I do not think that if these were criminal allegations, any of them would cross that line whereby the case has been made out, because the part I played in this matter was only in terms of prima facie, and prima facie only has to do with the facts as they are before you, or the allegations, and any supporting fact, any supporting material as has been presented to you. Isn't that it? Mm-hmm. So, like I said, I didn't see what is in what came before them beyond what I had earlier on seen. And what I had earlier on seen was insufficient. Yes. It didn't even cross into the inquiry stage.
So a committee, in your opinion, should not have been set up to inquire into it?
I think it follows, doesn't it? It follows.
I mean, a number of your concerns rest on a lack of clear laws in place and everything. To the extent that the committee was exercising discretion and their own understanding of some of these laws and applied it, would you disagree or agree with those who say that no clear-cut provision has been breached in terms of from the start of the procedure for the removal to their conclusion?
Well, what procedure? That skeletal framework that's in the Constitution? See, that's a very. I want to take you back to the Ajay case. See, in the Ajay case, the court, the matters had only just begun. The process had only just begun. So we couldn't really go deeply into other aspects that could have come up. But the court perceived, rightly so, that the procedure that has been set out for the removal of the Chief Justice fell so far from normal standard of justice that we had to read a procedure into it. for the simple reason that for the removal of a normal Superior Court judge, there's a stipulated need for a prima facie determination. And then for the removal of the Chief Justice, there was no such thing. Yes. And so we read the need for, because otherwise, why should it even go to the Council of State? If it goes in and it comes out, what would have happened to it? It goes for them to look at it. So we decided that there too, there has to be prima facie. Because when you're dealing with constitutional processes of this sort, there are all kinds, it's nuanced. And you need to, as much as possible, shore up the provisions to reduce the room for play of nuances. You need, so as to create more certainty. I think that's the best way I can put it. We didn't get to the stage where we were to determine, okay, I'm the one who speculated. It was so obiter. Yeah. But the court itself did not go into are the grounds sufficiently clear. We didn't go into that. But this was an opportunity for that to be also done. Yeah. I've done in connection with the article, I had to do a prima facie finding once, and I certainly decided to go to. I treated it like I'm a High Court judge who's making a prima facie finding in a criminal case, and the standard had to be really very high. And at the same time, one also had to take into account the circumstances. See, because stated misbehavior simply means you're supposed to have misbehaved in this regard. But as to whether it has the weight to amount to misbehavior that should have certain consequences, that is an evaluation. That is also nuanced. Yes. And in my opinion, most of the things that had been brought against the respondent, I threw them out because de minimis non curat lex. What does that mean?
The law does not concern itself with things of trifle, not substantive matters, not little things. Yeah, but if I'm to ask directly, would you say that the former Chief Justice got a fair trial, if I'm to put it in that manner?
In my, you want my opinion, you want my legal opinion, you want an opinion from the heart and the mind and the soul and the spirit? No, she didn't. She didn't. And there were also other things which in the latter part of the proceedings also happened, which I don't even know how to put it, but they were very unbecoming. One, a process that is supposed to be purely in camera, and that expression in camera has been defined by the Supreme Court, and that definition still remains, right? that from the complaint all the way till the president speaks at the end of the matter, it's all what? It's all to be treated as part of the same thing. It comes under the same cover of in camera, and therefore is supposed to be confidential. So you can imagine the umbrage that I felt to receive on social media some social media thing somebody had sent to me, where the fact of which I am not in the least bit ashamed, and if I had to do the same again, I will. The fact that I had gone to give evidence before the committee was on social media. How did that get there? And it was not only myself. So and 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 so. I'm not going to repeat that. I won't use the word that came on my lips. I'm not going to repeat that unbecomingness by even mentioning the names that were mentioned. Isn't somebody entitled to have every witnesses on their behalf? And then to come to think of it, then I thought, yeah, but we don't even know who gave evidence on behalf of the petitioner. So why is it that those who gave evidence for on behalf of the respondent, why should we be thrown to the rabid dogs? Because there has to be some not very noble motivation for that. And when it says that they from quote and unquote sources close to the committee, oh really, that is so sad and it's so pathetic. And then on Sunday, somebody sends me another thing where somebody's going on and on and on and on and going on about the legal submissions that had been filed on behalf of the petitioner. Really? Why? Why? What's the game? What's going on? I felt sad. And even that in itself made me sad. Have we come to this in this country where a process, the most important thing in every process, whether it is a formal judicial process or it is the most informal process, such as, let's say, ADR discussions and all that, where something is supposed to be confidential, it has to be kept.
But to the extent that the Supreme Court has determined that if there is a breach of the in-camera rule, it does not invalidate the process, should that still be of concern?
That does not matter. I'm still talking about it. Just because it doesn't breach it, it breaches the letter. It breaches the letter of the Constitution, does it not? That it should be confidential. I'm not saying it therefore means anything, but all I'm saying is that for me, it puts an unpleasant aroma onto the procedure, because process integrity is exactly that which is demanded of the most humdrum, the most mundane inquiry, let alone an inquiry into whether or not a Chief Justice should be removed or not.
Outside of that concern, what other matters constitutes the basis for your conclusion that you don't believe she got a fair trial?
Oh, I didn't say she got. Maybe what I meant is she got, after all, it wasn't a trial, even though it was handled as though it was a treason trial.
Why do you say so?
Because that's how I feel. Because that is how I feel. Am I entitled to feel? Am I?
Yes, but to the extent that a petition was sent, a committee.
Listen, you know, a petition was sent. It went to the Council of State. It came back. A committee was set up. Yes. Then you get into the qualitative aspect of things. And you see my upset and I won't use the word anger because I don't waste my anger on certain things. But my discomfiture also arose from the fact that when the Chief Justice, and that one is a matter of public knowledge, right? When she applied that, okay, since the pleadings are all now out there in the public domain, why can't we simply have a public hearing? She was told what? No, it's supposed to be in camera. It's supposed to be in camera. Everything is confidential. So I go to an in-camera process to give evidence, and then it's out there in the public domain. Approbation and reprobation, that's the way I see it. The committee, whether either it was not protecting itself properly, because really, who came? Because as I was walking into that building, I didn't see any paparazzi within sight. Okay? Nor did I see any person surreptitiously maybe taking pictures or anything like that. So how it got to the press that so and so plus me, we had given evidence, I think that is wrong. And it was in bad faith, and it was in bad form, and it was not in consonance with the due process, the due regard that is dictated by an in-camera process.
In the course of the hearings, there were a number of court decisions.
I didn't follow any of them.
I mean, the multiple attempts, and I'm asking this because some of the concerns that you've raised were all matters that were put before the courts in one form.
I did not
or the other.
Follow any of them. The few that I didn't really follow the details of them. Some of the outcomes were a little too predictable. I didn't follow because as far as I was concerned, the whole thing shouldn't have been happening in the first place. So I had shut my mind to the whole process. After all, I'm no longer a Chief Justice. My sole role in the whole matter was whatever came before the Council of State. That was passed. How I felt about it, how I didn't feel about it, was neither here nor there. So why should I follow it? And at this point in time, I'm not even going to say the Supreme Court was right or was wrong, or this court was right or was wrong. That's all neither here nor there. It has happened. And all I can say is that I just pray to the Lord that in fact, no judge and no Chief Justice henceforth ever has to go through this rigmarole again. That's all I've got to say.
In commenting on the decisions, you use the word predictable. If you could explain, is that to say that predictable in the sense that it was the conclusions that the court ought to have reached, or you mean predictable in a different sense?
It was predictable in the sense that, well, not all of them, but some of them were predictable because one knew what to expect, not because the law said so, but the law was, there was room for discretion, and it didn't happen. But then you cannot fault somebody for not exercising a discretion. That's not a big deal.
Do you think the entire removal process was politically motivated?
I refuse to answer that question on the grounds that it might incriminate me, quote and unquote.
Incriminate in what sense?
I said quote and unquote. I'm not going to answer that. You know, I mean, observe, and everybody can make their own conclusions. That's all I can say. I mean, whether it was, whether it wasn't, it has happened. So I'm not even going to comment on that.
When the committee submitted their reports to the president, they did indicate that they had concluded work on just one and they had adjourned on the others. There are those who have taken the view that the committee perhaps should have waited and finished with everything before submitting the reports. Where do you stand on that?
Well, all I can say is that I found it a very peculiar I found it peculiar because having brought in the first report, it has been acted on and the matter is now moot. The rest of the complaints are moot now, aren't they? Under what circumstances and for what reason and with what justification is Justice Tokonu going to be dragged before any committee to answer to the remaining petitions?
What do you think would have been appropriate for the committee to perhaps finish the complete work before submitting the reports?
You know very well that when somebody has done their, you know, in a situation where there are no hard and fast rules and a body has decided to proceed in a particular manner, it becomes difficult to say that. The most you can say is that if I was in charge, I wouldn't have done it that way. Yeah, because that's why cases are consolidated, and or you hold on, and then you come up with your conclusions when you have concluded the process. So is the process complete or is it not complete? That's the question. But I think it is complete. Is it not? Yeah, it has a terminal outcome. It has created it has had a terminal outcome. There's nothing left. So I'm even surprised mention was made of those other petitions.
If there's one lesson you think should be picked from all what has gone on in the last couple of months, what would that lesson be for you?
That a constitutional provisions that purport to deal with the removal of persons from their positions, however high, however low, ought to be ought to be crafted with more precision and have greater detail. Because if in your constitution you're going to go to the extent of setting out grounds, setting out procedure, and saying that this is the only procedure that is to be used, then it needs to be more solidly grounded. It needs to say more. Because what the Constitution could have said, actually, would have been that etc., may be removed in accordance with a law to be made by Parliament. Because just like there are other provisions of that nature, that could have been done. But once you stipulate that this is it, then it should have been, there should have been more substance to it than as it is in the present Constitution. So any takeaway, well, any lesson, not for me. I'm over 70. I'm in the departure lounge. But it's that when it comes to constitutions, what is inside it, how it is phrased, the specificity with which it ought to be phrased should all be carefully looked at. Because every constitutional outcome is not towards an individual. It is towards the nation and its future.
Okay. There's been a bit of legal debate, just final two questions. There's been a bit of legal debate on the effects of the removal, whether it affects her role as a Supreme Court judge as well. The warrant that I have seen removes her from office as Chief Justice and Justice of the Supreme Court. Is that your understanding of what the 146 procedure should lead to in respect of the Chief Justice?
See, that's also another gap. That's what I'm going to say. That's also another gap, because it has to be dealt with. And because just yesterday, except I wasn't really paying much attention, but somebody drew my attention to something in some decades past where somebody was removed as Chief Justice but went back to serve on the bench because of the terms in which the removal was couched. I think it was by way of an enactment. I can ask the person to give me more details just for edification, but you know, I don't want to go into academic debates, and I will rather, this is as far as I will go with answering the question you have asked, because for all you know, in this litigious country, somebody may bring a matter before the Supreme Court just for the heck of it, and I don't want to put my mouth in there.
And finally, I mean, if you were to say something to the former Chief Justice, what would you say to her? I mean, and secondly, do you think that we need serious, clear-cut reforms to guide this entire process?
I think I've made it quite clear. I'm answering the latter part of your question. Yes, clearly. Not only whatever will be in the Constitution, but even in terms of the procedure before the committee. There has to be something there. Yes, under the general law, every committee sets its own procedure, so long as they do not breach the rules of natural justice. They are legitimate, but there are all kinds of nitty-gritty matters that it would serve the nation better if it is all there in the law or in the Constitution, and it is there for everybody to see and for everybody to know, because that is why criminal procedure is more of a technical part of the legal instruments than civil procedure. Civil procedure has a lot of discretion, but because of the nature of the possible outcomes of any criminal process, criminal procedure has a lot of imperatives, and that is what is needed for this kind of activity. Because it's not only judges who can come under the Article 146. All the constitutional bodies, the heads, yeah, and even that, I have serious problems with that. I mean, can you imagine? God forbid, but proceedings are being brought against the Auditor General or the Accountant General, and that process, because these are all classified as of the rank of Court of Appeals judges, so this becomes the headache. There's a limitation on that. So that those provisions, they need a real serious of, so that the removal of some of these positions would be done by specialized bodies. It's only fair, right?
And the other part of the question?
The other part of the question, which is what? I've conveniently forgot. Yes.
And if you had the opportunity to speak to the former Chief Justice, I mean, she publicly expressed serious concerns about the process that she was going through, that she felt it was unfair. It's come to an end. If you moved there, if you had the opportunity, what would be that one message to her?
That she should take heart, that God sees. And sometimes when you go through certain things which you think have brought you to the end or to your knees or something like that, that could be far from the truth. There could be bigger, better, and greater things that the Lord has in store for her. That is what I will tell her, and that is what I'm going to send to her as a text message. Because when you're a believer, things is happening today. Yeah.
Optima Solar Systems offers reliable solar energy solutions in Ghana, including solar panels, lithium batteries, energy solutions in Ghana, including solar panels, lithium batteries, water heaters, water pumps, and solar-powered CCTV. They provide installations, ongoing maintenance, repairs, and more, and even comprehensive solar insurance against theft, against fire, flood, and so much more. Flexible payment plans are also available to you. Their services suit homes, farms, businesses, and they help customers cut down electricity bills and gain energy independence and support the environment at large. You can give them a call on 030 824-9900 or 050-502-3472. Check out their website on www.optimasolarsystems.com or follow them on social media on Instagram and Facebook at OptimaSolarGH. All right, that's our show for today. We'll be back tomorrow at 6 a.m. with another edition of TV3 New Day. My name is Na Ashoko. I've been on today with Cookie T and Roland Walker. Enjoy the rest of our programs. Goodbye.